Hello viewers, in the last session we discussed directors, removal, powers and duties. In this session we are going to discuss company meetings and resolutions. Lesson will explain the various meetings of a company that the company should conduct and the various powers that the shareholders can exercise by passing resolutions at the shareholders' meetings. A meeting may broadly be defined as the gathering, assembly, or the coming together of two or more persons for transactions of any lawful business. Since the term meeting connotes coming together of two or more persons, therefore, a single person cannot usually constitute a meeting even though he holds proxies for several other persons. The Act, however, provides certain exceptions when presence of one member alone would constitute a valid meeting of the company. One-man meeting. The circumstances when a meeting attended by even a single member of the company shall be held valid are stated below. When the tribunal calls a meeting under section 97 or section 98 of the Act respectively, it may direct that one member of the company present in person or by proxy shall constitute a valid meeting. If the share capital of a company is divided into different classes of shares and the shares of a particular class are held by a single person, the presence of that person alone in the class meetings of the holders of the shares of that class would be enough to constitute a valid meeting. Requisites of a valid meeting. Meeting must be called by a proper authority. The proper authority for calling the meeting is the board of directors. A meeting called by the secretary of the company without the authority of the board was held to be invalid, but the notice to call such meeting is ratified by the board. This principle was laid down in Re Hay Craft Gold Reduction and Mining Company, 1900, 2 Chancery, page 230. Notice of general meeting. According to section 101, subsection 2 of the Act, that a proper notice of the meeting should be given to every member of the company. Omission to give notice to a single member may invalidate the meeting. Notice should be in writing and must be given 21 days before the date of the meeting, excluding the date of service of the notice and the date of the meeting. The notice must specify the exact place, date and time of meeting. The notice must contain a statement of the business to be transacted at the meeting, and where special business is proposed to be transacted, the notice calling the general meeting must be accompanied with the explanatory statements. Quorum. Another requirement of a valid meeting is the presence of a quorum. Quorum means the minimum number of members that must be present at the meeting. It is generally for the articles to provide what number of members will constitute a quorum. But section 103 provides that unless the articles provide for a larger quorum, 5 members personally present in the case of a public company and 2 in the case of a private company shall be the quorum for a meeting. If within half an hour from the time of a meeting a quorum is not present, the meeting will stand dissolved if it was called upon requisition. But in other cases, the meeting is automatically adjourned to reassemble on the same day in the next week. If at the reassembled meeting also a quorum is not present within half an hour, as many members as are actually present shall constitute the quorum. Chairman. For the proper conduct of business at a meeting, a chairman is necessary. His appointment is usually regulated by the articles. In case the articles are silent, the members personally present at the meeting shall elect one of themselves to be the chairman. He is responsible for the proper conduct of business at a meeting. If a poll is demanded on the election of the chairman on a show of hands, it should be taken forthwith. If some other person is elected as chairman as a result of the poll, he shall be the chairman for the rest of the meeting. Voting. Regulation 56 of Table A in the first schedule to the Act provides that, subject to any rights and restrictions for the time being attached to any class or classes of shares, A. On a show of hands, every member present in person shall have one vote, and B. On a poll, the voting rights of members shall be as laid down in section 47, is essentially declaratory in nature, and it is left to the articles to determine the number of votes each member shall have on show of hands and on poll respectively. Voting by show of hands. According to section 107 of the Act, in the first instance, voting on a resolution takes place by show of hands. In this case, each member present in person counts for one vote only, irrespective of his shareholding and even if he holds proxies. Poll. According to section 109 of the Act, lays down that since voting by show of hands may not always reflect the opinion of members upon value basis, and so the section provides for demand of poll. A poll may be demanded even before the declaration of the result on a show of hands. When a poll is ordered, the decision on a show of hands has no effect. Proxy. According to section 105 of the Act, that any member entitled to appoint another person, whether a member or not, as his proxy to attend and vote on his behalf, but a proxy so appointed shall not have any right to speak at the meeting. The rules relating to appointment of proxy is contained in section 105 of the Act. Minutes. The word minutes denotes a brief summary of the proceedings of a meeting. Each company has to maintain a record of the proceedings of its general meetings and the meetings of its board of directors or of every committee of the board. Section 118, subsection 1 of the Act provides that every company must maintain minutes of all proceedings of every general meeting to be entered within 30 days of the conclusion of such meeting in a minute book kept for the purpose with its pages consecutively numbered. Pasting of papers in a minute book is not permissible. The minute book must be dated and signed by the chairman of the meeting. Kinds of meetings. The meetings of members of a company may be divided into two broad heads, namely general meetings and class meetings. The resolutions passed in the general meetings are binding on all the members of the company and the company itself. On the other hand, resolutions passed at the class meetings are binding only on the members of the class. The general meetings of a company may be of two kinds, namely annual general meeting, extraordinary general meeting. Annual general meeting. Section 96 of the Act lays down that every company, whether public or private, has to hold a periodical general meetings of its members annually for the purpose of transacting its routine ordinary business. Such a meeting is called the annual general meeting of the company. The Act requires that every company other than one person company must in each year hold an AGM in addition to any other meeting in that year and must specify the meeting is an AGM in the notices calling it. The first annual general meeting of a company must be held within 9 months from the date of closing of the first financial year, and then no meeting will be necessary for the year of incorporation. Thereafter, one annual general meeting must be held every year. The gap between one meeting and the next should not be of more than 15 months. There is no provision in the Act for deferment of the first AGM. If the company fails to conduct this meeting, the following are the two consequences. A. Any member can apply to the tribunal and the latter will order the calling of the meeting. An application can be made by any member under section 97 of the Act. The tribunal can give an order which it thinks expedient in relation to the calling and conducting of the meeting. A meeting held in pursuance of this order will be deemed an annual general meeting of the company. B. Section 99 of the Act lays down that the failure to call this meeting either generally or in pursuance of the order of the tribunal is an offence punishable with fine. The penalty is posed upon the company as well as every officer who is in default. C. Proviso to section 96 lays down that the ROC has been given the power for any special reason to extend the time for holding an AGM for a period of only 3 months. But the time for holding the first AGM of a company is never extended. D. Section 96, subsection 2 lays down that the meeting should be held during business hours, that is, between 9 a.m. to 6 p.m. on a day which is not a public holiday, and at the registered office of the company or at any place within the town where the registered office of the company is situated. The central government may exempt a company from this subsection. Section 2, subsection 38 lays down that public holiday means a public holiday within the meaning of the Negotiable Instruments Act 1881. Importance of AGM. It is desirable that the shareholders should come together once in a year to review the working of the company. The equity shareholders will take major policy decisions in this meeting only. The business to be transacted at the meeting is generally provided for in the articles of the company, and that is known as the ordinary business of the meeting. The meeting may take up any other business also, and that will be known as special business. Extraordinary General Meeting. Section 100 of the Act provides for calling of extraordinary general meeting. Clause 42 of Table F of Schedule 1 provides all general meetings of a company other than the annual general meetings is called extraordinary general meetings. Extraordinary general meetings may either be called by the board of directors voluntarily whenever they wish to transact some special or urgent business which cannot be postponed till the next annual general meeting, or it may also be called on the requisition of a specified number of members. The requisition must be signed by holders of at least 1/10 paid up capital having right to vote on the matter of requisition. If the company has no share capital, the requisition must be signed by as many members as have 1/10 of the total voting power. The meeting can be called by giving not less than 21 days notice in writing by the requisitionist, and the meeting should be actually held within 45 days from the date of requisition. The meeting can be called by giving even a shorter notice if consent is accorded thereto by members of the company holding not less than 95 of such part of the paid up share capital as give a right to vote at the meeting. In case of a company not having share capital, the members holding not less than 95% of the voting power exercisable at that meeting must consent to a shorter notice. If the directors fail to do so, the requisitionists may themselves proceed to call the meeting and conduct the meeting at the registered office of the company within 3 months from the date of requisition and claim the necessary expenses from the company. The requisition must set out the matters for consideration of which the meeting is to be called, and it shall be signed by the requisitionist and deposited at the registered office of the company. No other business other than the one for which the extraordinary general meeting is called can be transacted in such a meeting. Power of tribunal to call meetings of members, etc. Section 98 of the Act provides that where the holding of a meeting other than the AGM has for any reason become impracticable, the company should apply to the tribunal. In such cases, the tribunal may, at its own motion or on the application of the director or a member, order a meeting to be called and held in accordance with its direction, and also give ancillary or consequential direction which it deems expedient, including a direction that one member present in person or by proxy shall be deemed to constitute the quorum for the meeting. If any default is made in holding a meeting of the company in accordance with section 96 to 98 or in complying with the directions of the tribunal, the company and every officer of the company who is in default shall be punishable with fine which may extend to 1 lakh rupees, and in the case of continuing default with a further fine which may extend to 5,000 rupees for every day during which such default continues. Motion and resolution. When something is proposed or proposition is formally made at a meeting, it is called a motion. A motion need not be adopted as it is. It may undergo amendments and changes when discussed by the members. A motion, when adopted, becomes a resolution. A resolution, therefore, is the decision of the persons present at the meeting, either personally or by proxy, which is arrived at after due deliberations. A valid resolution can be passed only at a meeting which has been duly convened and duly constituted with the requisite quorum. After the motion is proposed and seconded, it is put to the meeting by members or chairman. If the requisite number of persons votes in favor of the motion, it becomes a resolution. Kinds of resolutions. Section 114 of the Act states that resolutions are of two kinds, namely ordinary resolution, special resolution. Ordinary resolution. A resolution is said to be ordinary when the votes cast in favor of it at a general meeting of a company exceed the votes, if any, cast against the resolution. It is a resolution passed by a simple majority of the shareholders present and voting. Special resolution, on the other hand, requires the support of not less than 3 times the number of votes cast against the resolution by members so entitled to voting. It is necessary that an intention to propose a resolution as a special resolution should be specified in the notice calling the general meeting, and text of resolution must also be set out in the notice. A typed or printed copy of every special resolution must be registered with the Register of Companies within 30 days of its passing in the meeting. Matters requiring sanction by ordinary resolution. Ordinary resolutions are required in the following matters. Section 16. To rectify the name of a company. Section 61. To alter share capital of a company. Section 123. To declare dividend. Section 139. To appoint auditors. Section 152. To appoint directors. Section 169. To remove a director. The above list is illustrative only. Matters requiring special resolution. Special resolution is necessary in the following matters. Section 13. To alter the memorandum of association of a company. Section 14. To alter the articles of association of a company. Section 66. To reduce the share capital of a company. Section 304. To wind up the company voluntarily. The above list is illustrative only. Resolutions requiring special notice. Section 115 of the Act provides that where by any provision contained in this Act or in the articles of a company, special notice is required of any resolution, notice of the intention to move such resolution shall be given to the company by such number of members holding not less than 1% of the total voting power or holding shares on which such aggregate sum not exceeding 5 lakh rupees as may be prescribed has been paid up, and the company shall give its members notice of the resolution in such manner as may be prescribed. Cases where special notice is required. By virtue of the Act, special notice is required in the following matters. Section 140. For a resolution at an annual general meeting to provide expressly that the retiring auditor will not be reappointed. Section 169. For a resolution to remove a director before the expiry of his period of office. For a resolution to appoint another director in the place of the so removed director. The above list is illustrative only. By hearing this lesson, the viewer will come to know about the various shareholders meetings of the company that the company should conduct and various types of resolutions that company can pass in the shareholders meetings. I hope you enjoy the session and we will meet in the next session. Thank you one and all.